this entire proceeding is ended.
With that gavel, Chairman Joseph Biden ended 3 of the most remarkable days in the history of the Congress. Senators investigating allegations of unwanted sexual advances by a Supreme Court nominee had waded out into uncharted and often seamy waters, hoping to arrive at the truth. But when the hearings ended at 2 o'clock this morning, 33 hours and 22 witnesses after they began, the Senate was right back where it started, having to weigh his word against hers. Anita Hill, a University of Oklahoma law professor, worked for Clarence Thomas during the early 1980s at the Department of Education and at the Equal Employment Opportunity Commission. She appeared before the Senate Judiciary Committee to tell her story.
His conversations were very vivid. He spoke about acts that he had seen in pornographic films involving such matters as women having sex with animals and films showing group sex or rape scenes. He talked about pornographic materials depicting individuals with large penises or large breasts involved in various sex acts. On several occasions, Thomas told me graphically of his own sexual prowess. Because I was extremely uncomfortable talking about sex with him at all, and particularly in such a graphic way, I told him that I did not want to talk about these subjects.
Judge Clarence Thomas had appeared to be within days of confirmation to the Supreme Court when the Anita Hill story broke. Now he was forced to return to the Judiciary Committee to defend himself, and did so with a blistering attack against his accuser, his opponents, and against the committee itself.
In the fall of 1991, a stunned and confused nation watched a law professor charge a Supreme Court nominee with blatant sexual harassment on primetime television. Stunned because never before had there been this kind of media attention to sexual harassment. Confused because the lines can seem unclear and sexual harassment is inextricably aligned to perception. Shortly thereafter, the nightly news and national magazines carried stories of widespread sexual harassment and discrimination in the military. Those events brought to light something that millions of Americans already knew. Sexual harassment and retaliation is a pervasive, destructive, social, legal, and ethical problem. And it is a problem which workers have not escaped. Sexual harassment, a form of sex discrimination, and retaliation for reporting it is one of the most persistent and destructive problems in the U.S. workplace. While potentially a problem for both sexes, the majority of sexual harassment is from men to women, and few working women have not experienced sexual harassment. Although sexual harassment is clearly illegal, it continues despite the high cost to the employee and the harassed individual. And despite the protections of the law, many who have been harassed do not bring complaints. Sex role stereotyping, distribution of power, and socialization are among the chief factors contributing to sexual harassment. Filing charges can be humiliating. Victims may feel their charges will be ignored or downplayed, or they may be accused of behavior that invited the offensive conduct. They may be ridiculed, face hostility or retaliation, poor work assignments, reduced hours, poor evaluations, or even the loss of a job. Still others don't know their rights, are confused about where the lines are drawn, or simply don't know what to do. The Insider exclusive investigative news team discovered that physician assistants and nurses, mostly women, rarely reported incidents of sexual harassment or retaliation to their supervisors. The greater the nurses' and medical staff's distress, the less likely she is to report an incident. Sexual harassment and retaliation against those who report it is extremely costly in terms of both human dignity and human resources. Fortunately, the laws to protect nurses and physician assistants from sexual harassment and retaliation are already on the books. Compliant, sound institutional policy and nurses fully understanding their legal rights continue to be problems. What is clear is that sexual harassment and retaliation is against the law. Since 1964, Title VII of the Civil Rights Act has prohibited discrimination in employment conditions because of an individual's sex. In 1976, it was acknowledged that Title VII also prohibits sexual harassment as a form of sex discrimination. Unlawful hostile environment harassment may occur even where there has been no tangible job detriment, but where sexually harassing conduct is so severe or pervasive that it alters an employee's working conditions.
Today, the Insider Exclusive goes behind the headlines in sexual harassment Marilyn Ranson's story to examine how Ron Podboy of the Ronald Podboy law firm successfully won Marilyn Ranson's case. Ron has earned the highest respect from citizens and judges alike as one of the best criminal defense and civil trial lawyers in Denver and in Colorado. He has seen many innocent and hardworking people become victims of sexual harassment, retaliation, and nightmarish working conditions. And because of that, he is driven to fight for people who have been harmed by the willful or negligent actions of others. He's built a substantial reputation by consistently winning cases other law firms have turned down, and his amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Denver, Colorado. It is my great pleasure to introduce Ron Podboy to the show. Once again, welcome to the show, Ron.
Thanks, Steve. Good to be here.
Tell our audience a little bit about the type of law practice you have.
Steve, most of my practice is criminal defense, but I handle a lot of different criminal cases. Now, the case we're going to be talking about today, which was Marilyn Ranson versus Paladin Press, was an early Me Too case, allegations of sex assault, or quid pro quo sexual harassment at work. That's what got her fired. This was a woman who would not go along with inappropriate behavior at work by the boss, and the boss of Paladin Press was a guy named Peter Lund.
And tell us briefly a little bit about this defendant, Paladin Press. Who were they?
It was a rather notorious publisher in Boulder, Colorado. In their history, they had been prosecuted civilly because one case was out of Maryland, which had just heinous facts. A guy named Horn had a wife, and he had a child who was a quadriplegic who had gotten a $2 million settlement. He wanted the wife out of the way. He wanted the child out of the way so he could enjoy the $2 million. He hired someone after buying a book called Hitman from Paladin Press. Hitman was a book that set out how to kill somebody without being detective. Make sure you use the rent car for any transportation regarding identification, however that could play in. How to kill someone with a gun without getting blood spatter on your person. Really detailed instructions for how to kill someone. There was a case brought against him after this man and the Horn and the guy he hired to do the killing. They were both convicted criminally, but relatives of the dead brought the suit against him in Maryland. Now, the case was first, it was called Rice versus Paladin Press. The judge threw it out saying, First Amendment protects this. The Court of Appeals in the Fourth Circuit, it was a federal case, they said no, this case is going to proceed. Case settled after that. So there were no determinations with respect to the issues brought up relating to the First Amendment. ACLU lined up here on the side of the defendant. Other groups lined up. on the side of the victims groups, lined up on the side of the plaintiff. But, because of the case, the insurance company stepped in, said, we don't want the risk, take the money, we're done. That had also happened, a very similar case, out in Oregon against Paladin Press. This was a case where someone wasn't killed, it was an attempted murder, but same thing. And the courts, that case was allowed to go on out in Oregon. Again, it was settled. And what the courts were saying was, yeah, we have the First Amendment, but as a publisher, if you aid and abet a crime through your publications, you can be liable. But, the cases were settled, so we really don't know what a jury would have done or what any higher court would have done on appeal.
There are other cases in a similar fashion. For example, freedom of speech. Do you have the right to yell fire in a movie theater?
There are limits on free speech.
There are limits on all the rights. In this case, never established them because they were settled out of court. But getting back to Marilyn Ranson, she worked for this guy, didn't she?
Sure did.
Peter Lund, right?
Peter Lund was a guy who thought he could get away with anything. Big ego, treated the women in his office as his personal harem almost. He would go out for a jog, he would come back, take a shower, wear just a towel in the workplace, put his feet up on the desk, trim his toenails. This was in front of all the women in his office. It was mostly women who worked there.
And this is right here in Colorado, right?
This was in Boulder, Colorado. The case was tried in federal court here in Denver. We're 10th Circuit. Mm-hmm.
And what happened? Marilyn wouldn't go along with his quid pro sex.
Well, quid pro quo. It's kind of like, look, I'm going to sexually harass you. If you don't go along with it and provide a quid pro quo, you don't get the promotion. You may be fired. It was that kind of situation. Now, he would have parties. And at those parties, even with the husbands and boyfriends of the female workers there, he would go up and kiss the females on the lips, kind of like he was alpha male and he could do what he wanted. Marilyn wouldn't put up with this. He would come up to kiss her. She'd turn his head. She made it clear, I'm not doing this with you, okay? Finally, and we allege that it was for these reasons, she was fired, hence the lawsuit.
And what was the end result of the lawsuit?
The Paladin Press was found liable for her firing. Now, the economic damages, because of the style of her job, were not huge. It was $50,000. But the jury also put on that same amount, $50,000, in punitive damages. Punitive damages are meant to be a punishment. In this case, they were. It was not a huge verdict, but it was an important verdict. There were some interesting aspects of the trial. All the women who were part of the crew who were just idolizing Peter Lund, and of course there were women there who took the attitude, look, you don't like this? Don't let the door hit your back on the way out. That's the way it is here. They were on the defendant's side of the courtroom.
Groupies.
Exactly. They were in the back of the courtroom giggling and laughing with each other. I guess they thought they were showing good support. The jury looked over at him. I could see. Jury wasn't liking this. The defense attorney for Paladin Press did something which goes to show how important it is in picking a jury. He allowed on that jury a former U.S. attorney who knew, I later found out, who knew about the previous cases, the Hitman book cases against Paladin Press. So he, I think, looked with a bit of a jaundiced eye, particularly when it came to matters of credibility with Lund. In any case, he did end up being the jury foreman. He teamed up with a bright young female doctor on the case. As I came to understand later, they kind of controlled the jury deliberations. And Peter Lund and Paladin Press were found liable for really outrageous behavior in the workplace.
You couldn't have picked a better jury.
It worked out well, and total surprise to me, you know, federal juries are picked at random, like all juries. Only in a federal case, you have a larger jury veneer. People can be brought from all over the state.
We have your Director of Client Communications here, Bridget Podboy. We're going to bring her on right now so she can talk a little bit about how clients, when they come in with these type of problems, how she deals with that. So let's bring her on right now. It's my great pleasure to introduce Bridget Podboy to the show. Welcome to the show, Bridget.
Thank you so much, Steve.
You bring a lot of experience to this job that you have now, and you've had for a number of years, Director of Client Communications at the Podboy Law Firm. And when I say bring a lot of experience, you were in the airline industry previously for many years, and you've been the victim of sexual harassment and retaliation, etc. Can you tell our audience a little bit about some of those experiences and how you dealt with them?
In fact, I had my own personal experience. Let me tell you about one. At a hotel, minding my own business, we had a long layover. We went out to grab some lunch. And by the time that I came back, it was housekeeping time. They had their carts out. I didn't realize until I passed the room, there were two males cleaning the room. And I proceeded, didn't think anything of it, walked to my room. As I'm walking towards my room, two guys started walking faster. The maids started walking faster behind me. And I started to get afraid. And so I just started running, and I put my door key in, and I slammed the door and locked the door, called downstairs, and warned them that your two male maids were running after me down the hallway. And I reported it to my company. I called my captain and the FO and the flight attendant to let them know my situation. I was afraid to come back out of the room. So we still had several hours before we were leaving, and the captain and the FO, well, the crew, came down to my room to get me out of the room to make sure that I was safe. But I did report it to the company, and I reported it to the hotel. They never called me about it. I don't know if they talked to my company about it, because I know that we were not the only crew staying there. So I just wanted to warn everybody about that, but unfortunately, I never heard anything else back about that.
That experience and others, other experiences that you've had, really qualifies you for being the Director of Client Communications now at the law firm. And you have people like Marilyn Ranson, for example, that came into the office, and they have these stories. And what is your approach with them when you listen to someone tell what's been happening to them at their own companies?
You know, I can let them know that I can identify with what they're talking about and empathize with them, because I went through that and was subject to that myself. And reach out, talk to somebody, get help, get good legal representation, and, you know, your story could help others come out, whether they have been going through or they've gone through this sexual harassment, because a lot of people are afraid to speak out because they lose their jobs. They're afraid of losing their jobs. They're afraid of losing their families. They're afraid of a lot of different things. But you have to speak out, because it could help somebody else, you know, reach out and tell their story.
Yeah, well, that's very good advice. It's, you know, it's very hard for someone to speak out when they know they're going to lose their job and they need the money, you know, and then without the money, then maybe they're, you know, they might be rethinking, maybe this wasn't such a great idea, because a lot of times they're blacklisted. You know, other employers say, well, why did you leave that company? Well, I was fired, or I was sexually harassed, and they see a potential problem.
Exactly.
You know, and it's really a courageous thing to come forward, and I'm glad you're there at the Podboy Law Firm to really help these people, because they need, as the client coordinator here, they need someone like you to help them through these trying times, don't they?
I agree with you. A lot of people are just afraid of the unknown. They don't know what's going to happen if they speak out. And this can happen. This could be a male. This could be a female being sexually harassed. Speak out. Tell your story. Tell your story.
Well, I'm glad you're there at the law firm, and I want to thank you very much for being on the show.
Thank you so much for having me, Steve.
Most of your cases are criminal cases, but you do handle, a good amount of civil cases. And in the Me Too movement that you mentioned, sexual harassment, retaliation for not playing the game, right? What do you find to be examples in this day and age of sexual harassment?
The case that we're talking about here, which was Ranson v. Paladin Press, nobody was talking Me Too back then. Of course, those laws were on the books. Me Too, of course, is much more recent lingo. But, this style of behavior has gone on for so long. It's part of Hollywood lore to talk about the casting couch. And women are often put in a position which is very difficult. And it goes to this quid pro quo sexual harassment. Listen, you don't play the game, you ain't going to be around here. On the other hand, these days, there's something you have to be careful of. I think in choosing cases, is it for real? In other words, he looked at me out of the side of his eye, and I interpreted it this way, and I want to sue. Sometimes the pendulum can swing too far. We see that in all kinds of legal cases in the civil arena in different areas.
In reality, in these type of situations like Marilyn Ranson's, when you are sexually harassed, very overtly, very obviously, oftentimes when you make a complaint, you're terminated. You are retaliated against and you're terminated.
Even if you go to human relations, if it's a larger company, they have a human relations person. Very often that person will act to protect the person who is being accused. Why? Because that person's a bigwig, okay? And there is real reticence to challenge that person. And yeah, very often the person who makes the complaint is the one who's sent out the door. It's retaliation, pure and simple. It can be hard to prove, however.
Because you're going to have to get corroborating evidence, aren't you? You're going to have people come forward who work at the company who may jeopardize their own jobs.
Yes, and there was so much support of Peter Lund here that was an issue that we had to deal with. However, there was one person who testified at the trial. This is the kind of thing that was going on. Another thing employers do in these cases, and these are essentially employment cases, is try to hide the fact that the person who was terminated, who was being sexually harassed, was really a good worker. That was the case with Marilyn. She had a great record, okay? Top performance reviews. However, we had trouble finding that out. We could only find it out from her anecdotal evidence. Why? We also had testimony at the trial that, those records were destroyed. In other words, the employer goes, I dismissed her. Gee, she really was a good employee. Let's get rid of that paper. Hits the shredder, you're never going to see it again. And of course, the excuse often is, we have regular purging of records. We don't keep all that paper around, and that was just part of an office purge of records.
Which is good advice for every employee, that whenever they get a performance record,
keep a copy.
Keep a copy, because they will destroy it. You have the evidence with their signatures.
And, it's called spoliation in the law. You are really just trying to get rid of something as a company which is going to be evidence against you. However, I've had, spoliation in other employment cases. Depending on the judge, a really conservative judge might just turn down that motion and go, oh, no, I don't see this against the company. And I've had that situation. It can make these cases pretty tough. And employment cases in Colorado, tough enough already, believe me.
One final question. When you have clients come in your office with these cases, sexual harassment, retaliation, whistleblower cases, they've been retaliated to, how do you determine which case you're going to take?
Part of it is how clear the story is from the person who is complaining. And sometimes it works to engage in these cases early because they can go, just in applying for unemployment, there's going to be a hearing. Sometimes the employer won't show up at that hearing. Sometimes the employer sends a party to represent the company at that hearing who makes statements which are very easy to prove false. If that is the case, you're starting to get your nose under the tent on the case, and it can build from there. So, what you've asked me is a really tough question in a way to answer because there are a lot of aspects to it. But, first of all, you have to have a person who is believable, who is someone who you think is going to be able to talk to a jury and be believed, despite the destruction of evidence. Like we had in the Paladin case. Gee, we don't have any record. We're just saying she was a lousy employee. She was incompetent. She couldn't do her job. She couldn't get along with other people at the company. None of this was true, but you couldn't find paper that would say that.
Well, congratulations on a great result, and thank you very much for being on the show.
Thank you, Steve. Pleasure to be here.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.